We're going to start now. Today presenting on notice is Ellen Bacon-Wiley. She used to be a rate attorney and supervisor in Ladle 2, amongst a bunch of other things previous, and is now currently with CAP. She was not only invaluable to us when she was with Ladle, she continues to be invaluable as someone that we can talk to and vent to at CAP. So she's here today to present notice. It's changed a bit since the last hearing, so everybody should be getting credit. And questions that are asked of her, she'll repeat the questions for the people in Lancaster before she answers. And do you want questions to hold until after?
Yes, I think that would be, well, if I want, you can ask a question. If I want you to hold it because it may tie into something later, I'll tell you. Yeah, that's fine. Okay, and then my other little caveat is I can't answer questions about specific cases you may have for several reasons. I may have a conflict because I may have another party that on a case that I'm supervising at CAP or something like that. So I don't have time really to answer specific questions about your cases. I think Lancaster's on hold because I'm hearing music.
That means somebody fell off.
Okay, it's the cool jazzy Ladle holding music. Okay, for those of you who are new to Ladle who may have no idea what CAP LA is, I'm just going to talk briefly about what we do. We're the California Appellate Project Los Angeles. We're the administrative arm of the Court of Appeal. We have a criminal unit and a juvenile unit because those are the people that are allotted indigent counsel, appointed counsel for indigent defendants on appeal. So we deal with parents, we deal with kids, sometimes with third-party relatives. We deal with private actions to terminate parental rights coming out of 418, delinquency, and then there's the adult criminal unit. There are 4 staff attorneys in the juvenile unit. Last year there were 3.5 because we were down an attorney for a while. In that time, we processed 1,400 appeals out of Los Angeles and also a smaller number out of Ventura County, Santa Barbara County, and San Luis Obispo County, between 3.5 of us. Right now, the caseload at California Appellate Project is 55% dependency and 45% everything else. There are 15 criminal staff attorneys at CAP. There are 4 juvenile ones, and we are fortunately going to hire another one next month. Why do I tell you this? Because I need you guys to win more, okay? Come on, guys, help us out. I need you to win more. We are certainly not in a position where we are looking to get a lot more appeals generated for us. I am going to go through notice for those of you who were here last year. Some of it's the same, and some of it is modified because I did want everyone who participated to be sure to get that coveted MCLE credit. So the agenda is we're going to go over the basics, and I'll explain what that means and what that means in terms of what your role is in the courtroom, special circumstances, due diligence, substituted service. I added 2 things, timeliness of reports, because we get a lot of questions about that, and conforming to proof, because that has been a hot issue in the records lately. So, as last year, things that are not on the agenda, special appearances, conditional appointments, friend of the court. This seems to be a moving target with Ladle on what the policy is. I'm not going to get into it. You guys, it's whatever Ken says you guys are doing. Hague, I know Alyssa Skolnick, who I could not compete with her knowledge of Hague, has also come to train on that, so I'm not even going to touch it. 95% of ICLA, because I am going to talk about ICLA very briefly, and 95% of ANTHLE. So as to ICWA, I think there has been a movement towards parents' attorneys and minors' attorneys believing that ICWA is not their concern and not their job, and let the department and the court figure it out. I'm here to tell you that that's not really the case. ICWA is an empty win for your client if it prevails on appeal. We have a mom who is back for her third appeal on ICWA because, I'm sure it will come as a shock to many of you, Judge Diaz cannot get it right, that her parental rights have now been terminated for 5 years. She is not getting those kids back. Yet, she has hope every time she files another notice of appeal that this is it. It's not going to happen. It used to be when we prevailed on an ICWA issue at termination of parental rights, the Court of Appeal reinstated the parental rights. And you basically started over. And as an appellate attorney at that time, I would call my client and say, call your trial counsel, do a 388, do whatever you can. The Court of Appeal cut that off. So there was a case called Francisco W, where now basically it's a conditional reversal. It's reversed only to do ICWA, and then parental rights are reinstated, parents don't get to be heard, no 388, nothing, it's done. We've made this same pitch to minors counsel. CAP-LA did a training for them where we talked to them about the possibility of taking testimony at detention when a parent says, I may have ICWA ancestry, instead of doing this very common, often overlooked order of department to investigate. Put the parent on, swear the parent. Get all the information you can because it delays the process and it doesn't help your clients. Much like the 388, I think there's a lot of talk in the waiting area about, hey, if you have a Native American ancestry, they can't adopt your kids out. It's not true. It just makes it a lot worse. The first time, you kind of get a free ticket. If the case gets reversed for ICWA, if it comes back, and trial counsel did not object, and it goes the second time on appeal, it's an IAC claim. So if you are reappointed, the court says, oh, we got a remitter here on ICWA, you need to talk to your writ attorney, your senior attorney, supervisor, whomever, get a copy of that opinion so you know what you're looking for. You know which tribes weren't noticed, what the defect was, so that when you go in on remand, you're ready. Because if you miss it, it's an IAC. Okay, so that's 5% of ICWA. Ansley versus Superior Court, you have to read the case, guys. It's very clear from some of these records that some of you are very excited, yeah, I got a motion, and you have not read what it says. It is not about perfect notice, it's about things that were known to the department. I saw one recently where they filed an Ansley motion and the argument was, well, yeah, that was his mailing address and yeah, the notice went there, but he was working in Mexico. That's not it. It's not that father was in the hospital during this time. It's not his personal circumstances or her personal circumstances. It's what the law is. You have to read it. You should know that the department's going to come back at you with Justice P. Read it. It's about best interest. Read it. And I will tell you, I have a handful of appellate attorneys who are very motivated to change Justice P. And they keep trying to argue it, to push back on it. Okay, that's my 5% on it. And if you're new and you don't know what I'm talking about, you need to call a supervisor before you do anything. All right, so we're going to go over the basics. I know you can't read this. I'm going to tell you what it says. So last year I was here. I did my notice training. About 3 months ago, I opened up a record. And this is the notice that I get on a 2-6 hearing. For mother, recommendation, remain in foster care with a permanent plan of return home, adoption, tribal customary adoption in the case of an Indian child, legal guardianship, or placement with a fit and willing relative as appropriate. Guys, no! That's not notice! Was there an objection by trial counsel? Hell no! Did the bench see it? No! Nobody saw this! And that's when I drop my transcript, stand up and go, I am in crazy land. You guys have a lot of new people on the bench. Do not ever let this go. Yes, it's great. It says it was served on the parent, but read the body of it. Because you will not know what the parent thinks is going to happen. I don't know what's going to happen. And I know the law. So this is why I'm back, and this is why we're going over the basics again. So, if you think back, first year civil procedure law school, you should remember Mullane versus Central Hanover Bank has to do all about due process and how notice is part of that due process. When you're here because you want to help these parents, because you really are looking out to make sure everyone's rights are protected, this is the cornerstone of that feeling and what we do. We don't want the state just to come in and pull people's kids away. That's not okay. It's about due process. It's about that ability to hear. Even if it's a dad who hasn't had contact with this kid in 3 years. This was codified by the California courts in Dijon B, which was a discussion of 317E and the right to counsel, those types of things. Until parental rights have been terminated, both parents must be given notice of each step of the proceedings, and it has to comport with due process. The buzzwords you're looking for are reasonably calculated under all the circumstances to apprise interested persons of the pendency of the actions and afford them the opportunity to be heard. They don't have to be heard if they don't want to, but they should. One of my biggest tips when I was training attorneys at Ladle was to go online and look at the Child Welfare Policy Manual, because you will find kind of a lot of interesting information there about how social workers think and what their requirements are. And one thing, if you're really struggling with whether or not notice was proper, they have it spelled out, everything. They have due diligence, publication, requirements for alleged fathers, juvenile court, just general juvenile court proceedings, personal service, removal orders. So it is a good resource to go and look for if you're really struggling. The general provisions, I will say that every case that I've cited and all the statutes are in this separate handout listed for you, so you don't have to furiously jot down what's on the PowerPoint. This chart that Gibran was kind enough to copy because I couldn't scan him a legal size, is a summary of notice provisions that's done by county council. It looks a little bit intimidating if you haven't seen it, but if you spend some time with it, I think last year I told you that maybe you want to date it, just get to know it, swipe left. It will start to make sense to you. It also does have ICWA on here as well. It tells you what needs to be served, who needs to be served, how they need to be served. You should really have this with you in the courtroom so that you can do a quick check. It used to be when we had a lot of experienced members at the bench that we could sort of rely on them or their judicial assistant. I wouldn't do that anymore because you get things like what I just showed you. So 290.1, detention, 290.2, petition, 291, juris dispo, 292, 364, 293, the review hearings, 294, 26, and 295 is post-permanent living, or RPP hearings. Those are all the general ones. It's all in there. So now we're going to turn to special circumstances, the things just sort of outside of 290 et sec. When you have an alleged father, it's a constitutional right, and there was to be noticed, to have the opportunity to come to court and raise his status to presumed. He has to have that opportunity. And 7611D, of the Family Law Code, the one that allows him to become a presumed father if he's held the child open, has held the child as his own openly and taken the child into his home, was actually found unconstitutional by the California Supreme Court to the extent that it gives the mother basically the right to thwart dad's ability. That's why we have that Kelsey S. line of cases to become a presumed father. So alleged fathers, even if mom names, 3 men, all with first names only, they have a right to at least try and be noticed. So 316.2 governs alleged fathers. If mom names John, oh sorry John, oh never mind. He's not here. You know, at the detention hearing, doesn't know his last name, it doesn't matter. They still have to try and notice any alleged father that mom names because it has to let him know. The statute also requires that the JV 505 be included. I know we don't see whether or not that was included. I don't think it is actually. From the transcripts that I've seen when they do the due diligence on the alleged fathers, I don't see the JV 505 attached. Maybe the social worker does and just doesn't put it in the report. I don't know. Bypass provisions. If it is a no FR recommendation for mom or dad, the social worker is required to give you notice of that. They have to actually notice you which subdivision of 361.5 they are relying on. And this is where it can get a little comical, especially when I'm one step out of the proceedings, because they all like to say it's B1 for some reason, and it's usually not. But they do, the department has to notify the parent if it is a no FR recommendation and which subdivision of B they're relying on, so that as their attorney, you can help them work towards proving why they should not be bypassed.
Ellen, is
Yes.
this written notice?
I'm sorry?
Is this written notice for the bypass?
That's what it says. That's what the statute says.
I think one of our attorneys, the county council, made an oral representation that they were going to bypass. That's not okay.
Well,
But the parent wasn't there.
oh, okay, that's a problem. With a whereabouts, no, that's a problem. Yes, it does require written notice, and it does require a timeliness, and if not, I think you would have good cause for a continuance for sure. When you get to the appellate level, the issue is always prejudice, and so you're right, it's not okay, and you're going to get a court of appeal to agree it's not okay, maybe, maybe not, depending on which division you get, and if you could really tie it into the due process issue. Okay, 355.1 presumptions. When the department's relying on a medical expert, registered sex offender, somebody to show a prima facie basis that the child comes within the provisions of A, B, or D, I believe, they have to give you written notice that they're going to be relying on the presumption. Why? Because it alters your responsibility in putting on a defense. If the department plunks in their medical expert as prima facie evidence, then it does sort of shift much of the burden to you to rebut that presumption that the injuries would not have occurred but for neglectful conduct by the parent. There's a couple cases on it. Again, it's in that stapled handout. NRADP, the Court of Appeal held that specific and separate notice of the agency's reliance on the 355.1 presumption was not required. In that situation, the way they wrote the A count, they plunked the language of the statute right in the A count. So the Court of Appeal said, hey, come on, you knew. It was right there in the way that the petition was pled. So the fact that they didn't put it somewhere else, like for instance in LA, they put it usually at the last page bottom of the petition, there was no violation of due process. Prior to that, we had NRAAS, which said that the statute should have appeared somewhere in the petition. Here, I know typically what I see is the department intends to rely on 355.1, blah, 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 which I think is sufficient. Watch it though, because sometimes I have seen, and I will name names after this if you want, on certain county council who routinely, when they are introducing evidence at the trial, will say, and Your Honor, the department's relying on 355.1 with no notice. And sometimes I do not hear anybody jumping up and down from the other side of the table. This is concerning, okay? It's a notice issue. It's a due process issue, okay? It's like getting blindsided on, at an intersection. They can't do that. They have to give you notice. So be aware of that.
What is the remedy? Oh.
Is the failure to provide the specific subsection cause for continuance or cause for?
On a bypass or on a,
bypass.
it can be, yeah. Because Sue, think of it, if you're the attorney and they're saying, because they always get it wrong, just B or B1, It could be B10, B11, the termination of FR, the failure to reunify, the termination of parental rights, or B13, the abusive and chronic use. Sometimes it's all three, and those can be intertwined, but they're very different. The parent may have failed to reunify because the child reunified with dad and the case was closed. The parent may have waived, which I've seen. So there's a whole bunch of different ways. I think you're in a position where you're going to have to request a continuance. If it's B13, mom or dad may have done programs, and you have to have the opportunity to try and get those records. So I think it's a continuance.
So if the court wants to go forward, you're on day 59, you want to resolve as soon as possible, could you make the argument that it is not an option to continue the dispo and proceed with a bypass argument and the department has to give FR?
Depends on your bench. It depends on your bench and your client. I mean, don't throw reality out the window here. If you have a mom who is on child number 5, born with a positive talk screen, and she's not sitting next to you because she hasn't appeared since detention, I mean, let's not go crazy, okay? But if there's something reasonable there, that it's going to either be preparing your client to testify, going to get documents, or even going back and looking at those siblings' cases, because, you know, the department picks what they want in that report. It's not the complete picture of what the parents were previously ordered to do, what the circumstances were. So you may need time to go and review the siblings' reports, because sometimes the department doesn't even have them. They just have to put in those minute orders showing that those events happened, that the parent failed to reunify, or that parental rights were terminated, or whatever it is. Yes?
If notice is not sufficient for the department's use of the 355.1 presumption, what's the remedy there? If you don't want a continuance, do you waive that issue? Do you go forward without them using that presumption? How does that work?
Unfortunately, the remedy for most of these, because it's a due process notice issue, the remedy, if you can call it that, is a continuance. Because if they are now relying on medical testimony, let's say, you know, to sustain the A, you didn't know that, and you have not retained your own medical expert to look at the documentation, you may be forced into a continuance. If you say, I don't want a continuance and I'm choosing to go forward, then your client is most likely precluded from raising that issue in an appeal based on forfeiture or waiver, unless the appellate attorney can link it up to IAC. And let me take a step back. I hate to say IAC because I think many of you are probably newer attorneys, and even for those of us who have been an attorney for years, nobody likes to get an IAC claim or investigation or anything. Nobody likes it. We do not make a practice of looking for IAC. One of the things when the panel attorney who is appointed to represent your client on appeal, if they want to even investigate potential IAC, they have to clear it with one of us first. And we're scrupulous. We are not saying sure, because one, the court will give them more money. Two, because to take time to do the investigation and a potential writ of habeas corpus, but also because the way that we perceive our position is we're working together. We're not trying to set Ladle up, or even the Tri-County attorneys up, and you'd be surprised about what happens in the Tri-County courtrooms. There's a lot of submissions on petitions. They don't do adjudications. That's not our role, okay? It's in extreme cases where there's no tactical basis for what trial counsel did. And the other thing you need to understand is your client may love you in the court, in the juvenile court here, they hate you by the time it gets to the Court of Appeal. You were the worst attorney, you never returned their phone calls, they gave you all this documentation for a 388, you didn't file it, you didn't say anything. Recognize that that client is now the client of the panel attorney. They have to do their job. They have to call you Mr. Smeal, I'll use you as an example, because the client is saying, I gave Mr. Smeal all this information, he never called any witnesses on my behalf. And by the way, after that, Mr. Smeal forced me to sign this knowing and voluntary waiver of rights and plead no contest. And Mr. Smeal did this, and Mr. Smeal did that, and Mr. Smeal did that. We have an obligation to follow up with that. So please never ever take it as, oh crap, what did I do? I'm a horrible attorney, I shouldn't be doing this. This is what your client's telling us, and we have an obligation to see through it. Okay, sorry, I went way off tangent there. Okay. Okay, due diligence. Everyone's favorite thing. Not really. They're a pain. You guys have to do it. I mean, I can't really sugarcoat it for you. You have to go through and look at those addresses and cross-reference, you know, whether or not the notices were sent and whether or not there was a response. There's no way around it. You have to do it. If you don't, you are looking at potential IAC. Because your client will pop up and file that notice of appeal, undoubtedly. I know when I was with Ladle 2, Chad Elwell and I had to go through a 64-page due diligence with about, I don't know, like 38 addresses, and we just sat there and cross-referenced. It's a pain, but you have to do it. Why? Because again, we're dealing with due process. We're dealing with sort of the cornerstone of what we do for these parents, and to keep families together. So again, you're going to see in Claudia S. this reasonably calculated language under all circumstances to apprise them of the action and afford them to present their objections and the opportunity to be heard. For your purposes in the due diligence, it means that it has to be one desirous of actually informing the party. It would drive me nuts when mom would come into detention and say, yeah, I think dad's in Mexico. So they'll just do a due diligence. And you know it's not going to find dad in Mexico because he's not registered to vote in the United States. He's not a member of the armed services. He's in Mexico. So the due diligence isn't going to find him. And so it's very frustrating because sometimes it seems like it's a process of futility.
Can I ask a question?
Sure.
If you look at the policy manual, and also just in light of the language of that case, they're supposed to do whatever's necessary to try to locate contacting relatives, social media. The due diligences themselves don't reflect any of those actually more probably realistic ways of finding somebody. So is there any movement on that? I mean, is there any way to just challenge the actual due diligence because it's so outdated in terms of what they're searching and how they're looking?
Okay, hold on, Amy, because I'm going to get to that slide with the policy manual in 3 slides.
Excellent.
Okay. Okay, so Megan P. was not at Los Angeles, but it was a situation where they did a due diligence. The agency had dad with the wrong name. They had transposed some letters on his name. They were told, nope, this is his correct last name, but they kept doing it. It's very similar to when you get those reports and your client's address remains the same even though you know they're not there anymore and it's been updated. When you see that, you need to point it out, okay? And I'm sure you do, but point it out and say, you know what, I see the address on the front. My client submitted a notification, a mailing address, you know, 3 months ago. This needs to be amended on the report. I mean, I can, again, I'll name names after. I can hear county council, well, I never got a copy of that. Here, put it on the record. Okay, anyway. And going back to Megan P., they had also ignored the child support services, which I know is something that LA routinely checks. Arlene A. is the most likely means of finding the defendant. Standard Avenues, Amy, this is probably your case, Arlene A., and the citation is in the stapled one. Basically, it says where the party conducting the investigation ignores the most likely means of finding the defendant, the service is invalid even if the affidavit of diligence is sufficient. So when paternal grandmother is sitting in the courtroom at detention and mom says, I don't know where dad is, and everybody just lets paternal grandma walk out and nobody says, hey, do you know where your son is? And then he's not in the armed services, he's not registered to vote, he doesn't have any current address with the DMV, there's a problem because there's usually some paternal relative in the mix or some mutual friend. So as Ms. Einstein gave you a preview of, which I realize I cut and pasted this from the department website, so I realize it's incredibly small. But this is what the department's policy is on how to conduct a due diligence. All known relatives and non-relative extended family members, online telephone directories, including in other cities and outside California, DOJ, DMV, Registrar of Voters, Postmaster, Military Service, Jail Clearance, Probation Index, LexisNexis, YA for minor parents. It's not called YA anymore, but they haven't updated it. State Prison or Parole Index, Federal Prison Record Search, Leader Replacement System, no idea what that is. Child Welfare Services, Case Management System, Child's Birth Certificate, Vital Statistics Inquiry, Child Support, Los Angeles County and statewide child support systems, global locate, use of technology, including use of social media, other search efforts including asking CSWs of siblings. So no, Amy's right. I mean, other than the DOJ, DMV, Registrar, Postmaster, Military, Jail, and State Prison Index, I think that's much of what we see. Going to Amy's point, what can you do to challenge it? One, you can argue Arlene A and say due diligence wasn't proper here. The problem we have, Amy, is so many times these are done at the outset of the case before these people are found and they don't have an attorney. So the objections aren't made. You could try and tie this into an Ainsley motion, and I would attach as an exhibit the department's policy. And that would be, though, if somehow you could make the link that father or mother was easily discoverable through social media, or grandma was there at detention, or something. If you can sort of tie it into the prejudice aspect, you may be in a good position. I do know we had one, and it was Diaz, and someone, God bless them, argued Facebook, and I mean, I don't understand what you're saying, counsel. And I think he must have said it like to me, the due diligence is proper. I mean, so you got to keep pushing, because we all know if parents post themselves smoking marijuana or drinking alcohol, that's getting printed and copied to a report. I mean, so it's out there. They can use
And
it.
I think where we maybe want to use it, just as a tip, is at the end when you've lost track of your client and you're at the 2-6 and the department wants that due diligence so they can serve you. Those are questions that you probably want to be asked.
Right.
at that
Right.
stage.
Yep. Absolutely. Yes.
What about us objecting to the due diligence for the other parent?
Go for it. Go for it. But
I've had them go for it, especially because what I've instructed our attorneys to do is on the paternity declaration, under ways to find the parent, I've had them write down, father's Facebook name is blank blank.
Yeah.
And even, he's wearing a Letterman jacket in his picture. And then
I
the
think you're
judge...
going a little above and beyond there, Dennis.
And then the judge will say to the department, you do need to check Facebook.
Right.
Because we've given them good cause, and we've also done a solid to that parent if they do ever show up, because if they didn't get proper notice, this can help support the Ainsley.
Sure. I think there's a lot of things. My initial was how would I package this for the Court of Appeal as a standing issue, and how could I make the parent who was present agree? But there's a lot of issues sort of tied in with being a father or a mother, and that's relative placement. One parent gets that far, the other one doesn't. The potential of custody orders, all those types of things. I think we could make that pitch, but it would have to be done well, because sometimes the paternity questionnaires that moms fill out, they'll give you a corner on where he hangs out. So sometimes it's a little bit difficult, but if you can put in sufficient detail, then you might. But I think you would consider picking the right case to take up that challenge, and picking the right bench officer too. Yeah. Okay, Gibran, then Susan.
You can hang up now.
Oh, because I'm digging it. I'm liking the jazz music. Okay, thank you. Now I can see the time too. That's helpful. Okay, Sue.
The DCFS policy for due diligence, which we have on the first drive, by the way, under notice, the standards for due diligence, the 2-6, does not include inquiry of relatives like it does at DISPO. Do you have any idea why? Is that related to some case law or something?
No.
So.
I think it's under the assumption that the relatives aren't there. They're not coming before the parent's found, which we know, because we're in the trial court, not to be true. That oftentimes there are relatives of the parent whose whereabouts are unknown are coming because the family's still involved. I have one where the mom had actually made a plan of the child to live with paternal grandmother, and the department puts all over, we don't know where dad is. Did you ask his mom? Because she's right there with the kid.
So we should ask anyway.
I think
We should
so.
raise the issue.
Yes,
Okay.
yes. Jessica.
I was just wondering if there's any kind of valid staleness type objection to these due diligences. Is it like one and done, or when you're at a 2-6 and the due diligence is done and then the 2-6 goes on and on and on, because our clients come and go.
Yes.
And I've tried to make that argument unsuccessfully a number of times.
So when I was here a year ago, I said no, and then Ms. Viamil said yes, and found the case, which I should have written down to include. She found a case that said 6 months. That it was 6 months.
So there is like a strict line.
That's what she found, yes. So you could go to her for the site.
And you said Carolina law, and it was?
I did, I said N. Ray Carolina V. Oh, it must be Carolina V. But yes, I think so. I mean, I think the only scenario, Jessica, where I think that wouldn't be implicated is the denial of FR to both and the straight to the 2-6. You may not have had that much difference, but in normal cases, they do certainly get dragged out, and then you have to do publication, things like that. I do think there is a staleness objection, as I am informed by Ms. Payne.
And would that also apply for notice for jurors?
Yes. Well,
places
yes, but
like
it shouldn't be going out that
In
far.
places like Lancaster, where they do.
Well, but,
Okay, I withdraw the question. I don't want to give you offense.
I see these petitions and I'm going, wait, what?
Which, by the way, is no longer my fault.
Right, right. I assume that 14 months between detention and dispo is a problem, people. Okay, but now you got me off track again. I forgot to say that according to statute, due diligence has to be completed 75 days before the 2-6 hearing. All right, substitute service, which honestly always bugs the tar out of me. Okay, substitute service. So you can do substitute service if it's hand-delivered to a competent person, at least 18 years of age, at the parent's usual place of residence or business, but it has to be immediately followed by the mailing to the parent by first-class mail of the place where the notice was delivered, at least 55 calendar days before the hearing. So if you get something and it looks basically from the proof of service that it was a sub-service, just double check it and make sure that they followed it up, that you can read the signature, that you verify with the parent who is this person, that the address was correct, that there wasn't a missing apartment number or half or who knows what was going on. Just double check that with the parent if you can. I realize that sometimes these things come out and you do not have the client next to you to check because they are getting a due diligence and they're gone. But that's one of the things that we are looking at, and if you don't make that objection, then we have a problem.
So,
Yes,
so
Donna.
if you make the objection,
Yes.
and then they say, no, I feel, they haven't really followed the substitute service for whatever reasons, then they're going, and it was ordered that they serve the attorney. I'm not going to accept service because I don't feel it was valid, or I have to wait to appeal. It's one of the issues on appeal. That substitute service was not done properly.
No, you don't have to, Donna. If the objection comes out of your mouth, it is preserved for appeal.
Okay, so I don't have to do, but
You don't have to stand there and be like, I'm not taking that. But you would, Donna.
I
Because I know
feel so angry that they did it, and I read everything off, and so I figured, I told these, do not take service, and I'm going to make a continuing objection when I go back. Forget about it, I made it first, and I repeat myself, so it was really...
Yes, as long as you repeat yourself. And I can tell you, honestly, the objections, the problem, where we sort of have had some issues lately getting into what happened here with notice is with you wonderful, amazing floater/senior attorney ones. I don't know what they're called anymore. Floater/senior attorney ones. You guys go in and somebody's told you, nah, this 2-6 is no big deal. So you go in and you make your appearance and you're like, no direction. But notice wasn't proper. I had one last week where dad was calling in from prison every single hearing, and guess what? At that 2-6, somebody stood in for the attorney and dad was not on the phone, and guess what? I'm not very happy about that. Okay, so, and we've had 2 now where that's happened, where notice wasn't proper, the client's not there, and whoever was covering just went forward and made a no direction general objection. So if you are covering and your client is not there, pull the court file, see what's happening. Do not rely on your colleague's notes. Yes?
I have 2 questions.
Okay.
The first relating to what you just said.
Yes.
So, say you're a floater or anybody's on a case, and you pick up the case and there was a previous proper notice finding, but in looking at the file, you're like, ooh, that actually wasn't proper notice. Can you correct
Yes.
the record on?
Well, you can try. Okay,
Right,
so
you make the objection.
yes, that's what you're trying to do, is put it on the record.
Even though the finding has already
Yes,
been made.
and you can say, Your Honor, I see from my colleague's notes or from the minute order dated whatever, that the court made a proper notice finding, however, I'm objecting because of this, 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 and I'd ask that the court vacate that finding and order proper notice.
Okay.
And even, Jessica, if it wasn't on your watch, if it comes up, then you are covered.
Okay, and then my second question
Yes.
relates back to substitute
Okay.
service. I'm assuming, but I know you should never make an assumption, but so your client's not there, but you're looking at the substitute service and you're like, I have no idea who the heck this person is that signed this. It's on the department or the person responsible for notice to prove that it was a competent person at the parent's usual place of residence,
Yes,
correct?
but then you're getting into it, going over and telling county council that you need to get the worker on, then you have to sort of figure out how to fight. The most obvious thing sometimes is that apartment number, or that address that the department served was the address that they keep putting on the report, even though your client is now in a treatment program, or you know that your client's not there. You want to check that address. That, to me, is the one that's going to jump out most frequently. The other thing on notice, before I forget, is booking numbers and CDC numbers, guys. For some reason, and I've talked to Judge Downing about this, when everything rolled over to Odyssey, the clerks stopped putting in booking numbers and CDC numbers. So we have had so many notice of writ rights and notice of appeal rights that are probably sitting in a mailroom, either at the department or the county jails or state prisons, that were not delivered. So when you're checking that notice, if that CDC or that booking number is not on there, it is not proper. And it has to be redone because the client likely did not get it. Yes?
Also, if you call the records department or whatever prison your client's in, they'll give you the floor and the bed, and that's how they actually get the mail. Because even if the CDC's number is on there, it's the same thing. It goes to a mailroom, maybe eventually they'll get it, but you need the actual, so when you're doing a change of address form, because you know your client's in custody, make sure you include that. The department never does. It's never on their notices, ever, 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 and you can get it.
And a lot of
As
times,
long as but you have to have done your
Right.
change of address form.
yeah, and a lot of times we don't even see it on the department's notice or the clerk's notice. Carolina, yes?
A lot of the times too, they just put the prison's general mailing address, so I make it a practice to object because I know that there's certain prisons that have specific mailing addresses for inmates. So there was a handout a long time ago that was passed out, maybe we can circle it around again. Christine and I went through each prison and we outlined the addresses.
Yeah, I think it's cdcr.ca.gov. You can get it online and it'll print out all the mailing addresses for all the state prisons. And then I know in Marlene's office, we always had it for terminal annex, for any people in local custody, and then of course, Century Regional. Yes, Jessica?
Is there like a specific verifiable authority that can be cited to judges for why the booking number needs to be required? Because I recently unsuccessfully objected in front of a judge, and she said, tell me in the law where it requires that a booking number be included in order for that to make it to your client.
That's part of their address.
And well, that's what I argued as well, and this judge was not willing to reference the prison or California, Los Angeles County inmate locator website or any of that, and said that it went to this person's name and this facility. I think it's proper. And I was just wondering if there was any like authority that you're aware of that specifically says in order for a prisoner to receive their mail.
No, to anybody who has ever represented somebody in custody, there is a statute in the penal code relating to the policies of correctional facilities. My guess, Jessica, is it would be in there.
Okay.
That would govern inmate mail. Also, if you go to the LA Sheriff's Department, there is a link or a tab that says inmate mail, and I believe it is written there. Now, is it a statute? No, but it's written on there in the policy that it has to have the booking number. That's crazy.
I saw that, and I thought that was maybe judicially noticeable, perhaps.
And please tell me that the client's name was something like Marie Ortega or like something totally
It was a very common Hispanic
Jose Diaz or something like that, where there's going to be a ton of them.
I was just gonna say, I mean, to me, it goes to the definition again of basic due process. I mean, what good is notice, especially when you have, and the only way you can link any name to that individual is there has to be some specificity. And when a person's incarcerated, the booking number, the bed, the classification.
The birth date's not, I mean,
I know. I mean, I was completely floored when this happened.
Yeah.
I didn't really know what to argue.
Because absent
Like,
that, it's a
it was
defect,
absurd.
and I just would just look at the judge in the eye and say, I believe the court has created a judicial defect in notice.
there you
Just
go.
put that right on the record.
Judicial defect.
Ed Ray, Marlene F. That's what we got there. All right, Candy.
Substitute service, ICE custodies or ICE holds.
Yes.
I've had situations where the department mails it to the ICE facility because they're not given access to the people. And so the fact that some agent signs the thing, they're like, that's substitute service. To me, is not. Because first of all, it wasn't hand delivered, it was mailed to the facility. And then are those considered?
I would make that argument. I don't know of a case on point, but I certainly would make that argument. I haven't seen that scenario in ICE custody. For the general state prison and local, what they do is they fax it over to the guard. I mean, they already have procedures in place. So they fax it over to the facility, the guard will hand deliver it to the person. So it's coordinated through the litigation department and DCFS. I haven't seen it in ICE custody, but I know, are you still able to get ICE detainees to court, or is that stopped?
I don't know.
We haven't been able to get, since Obama left office, we haven't been able to get it back.
I would make the argument.
They're working in the kitchen.
Donna says that we should serve them at Mar-a-Lago.
Donna. All right. We're going to just go to reports real quick because we get a lot of questions about this. It's 10 calendar days, not court days, calendar days, calendar days. Doesn't mean court days, means Sunday through Sunday. For everything except jurisdiction, which says reasonable time. I couldn't tell you why. I don't really know why. I think because somehow the department advocated for some leniency when this legislation was passed under 355, but it does say reasonable time.
Probably because we sell a lot of no-time waivers.
I'm sorry?
Probably because we sell a lot of no-time waivers, that's when they like to give us more like 2 days for it.
And I would argue, that's the classic conundrum is you have the client sitting next to you who wants a no-time waiver, who has a right to a no-time waiver, and the judge is like, oh, they can't get you the report, 5 days before. These poor social workers, they're overworked. So it's reasonable time. Contested review hearings. Sue, I always want to think that Judith P. was your case, and I don't know why I always associate with you with this case.
Did you lose?
No, it was a winner.
Yeah.
It was a winner.
Wow. It's only.
So, about what I'm about to say is outside of Department 404, and maybe Emma Castro. She was trying to do this, but I don't know if she's still doing it. Judge Seidler is one of the few bench officers that I know of that does set a 10-day receipt of report for review hearings. Most of them do not. So if you go to this statute, it says 10 calendar days. Where the heck's my report? Because you know you get it the day of, sometimes the day before if you stay till 4:30 and stand there and stare at the court officer. So Judith P. was a result of our wonky policy here in Los Angeles. And in my head, I'm just going to say it was Sudell's case, because I don't know why. Basically, the attorney, not unlike many of you, goes in for the date of the, I believe it was a 2-1E, gets the report, the client's not there, the attorney cannot review anything in the report with the client, and the judge says, I'm not giving you a continuance. I'm not giving you a continuance. So that's where this case was born out of. The attorney did not receive the report 10 days before. The way that LA has sort of remedied this is, usually most of the bench is not going to stick you when you request a continuance or you request a contest. Well, are you going to disagree with me?
No, I just want, what I'm hearing frequently now is it was in the portal.
Is it in the portal 10 days before?
I'm sorry?
It's in the portal 10 days before sometimes?
If it's in the portal 10 days before, the attorneys have access to it, but our clients don't, right? So.
Right. But here's the problem with that, Olga, is somebody's going to come back and say, well, you're the attorney, it's your job to communicate it with your client.
Right.
And unless you can show the reason why you couldn't, enough to constitute a continuance under 352.
So then if it was in the portal 10 days before, the attorney had access to it in the portal, the client does not, then it's our responsibility then to provide it to our client.
It should be served because you have a notice issue too. I mean, this isn't separate from the notice issue of whether or not what the recommendation is. Continued FR, termination of FR, whatever, or HOP, whatever it may be.
But I mean
so you may have a notice issue.
Okay. So that could be a notice issue.
Yeah.
Okay.
Yes.
So the 10-day requirement, it says the failure to provide parents and children.
Because that's what the statute says.
Right,
Yeah.
which is exactly what the statute says. So does that actually extend to the attorney? Because a lot of them are now putting in the notice, the hit or miss, I'd say it's maybe 50%. They actually put the notice is sent and a little stamp that says report mailed. And if it's 10 days before and was mailed to your client, even if the attorney didn't receive it 10 days in advance, that comports with the plain language of the statute.
The notice statute, though, says parent, party, and attorney.
Okay.
It doesn't say or. It says and.
But that's for the recommendation, not necessarily
Right.
for the report.
Not necessarily for the report.
Right. So I'm saying the report itself. If just the attorney didn't receive the report and your client's not there, but in the report the notice was mailed to your client and it says the report was mailed to your client.
I would still argue GP.
Okay.
Because that was the issue. The client wasn't there. And what the trial court said was, look, you have your client. You should have talked to your client about it. And what the Court of Appeal said was, wait a minute, the attorney just got the report. They didn't have time to subpoena witnesses. They didn't have time to talk to their client about their participation in programs or visitation or verify anything in that report. So I think Judith P. would still be useful in that case.
But pretty much if they mailed it to the client, it's probably in the portal.
Yeah.
If they prepared it and mailed it, it's probably going to be.
I have 1 minute? Are you serious, Jabron? Okay, hold on. Okay. Okay, conforming to proof. This has been a big issue, so I'm going to go through this quickly because that's what we do with big issues. There's so many cases here that have come up lately. I'll give you my quickest scenario, which was Joe Mellis in 420, filling in for Jabron. Non-offending father, mom's addicted to heroin, case comes in, Greenberg says, I think after hearing all the evidence, father, I think you have failed to protect, and I'm going to go ahead and add you in that petition. Father wasn't there. He was not offending. He was waived. Joe Mellis jumping up and down. No, Your Honor, please, give me a continuance. Greenberg says, no, I'm going to go ahead and sustain that based on my conformity to proof, which I'm allowed to do. It went up on appeal. Everything's fine. But you have to watch conforming to proof. In Jessica C., this is sort of the seminal case on this. It's so wide, the amendments that the court's making and the original petition is so wide that it would violate due process. In Jessica C., it didn't. It was a sex abuse case. And the difference, the language of the filed petition was penetration, court sustained fondling, Court of Appeals said, yeah, you know, basically lesser included, it's good. We have a recent case out of 409 where minors counsel during calendar call says, I don't like this petition. I think we should add an A count. Department says, fine with us, we didn't get a chance to file an amended petition. They go forward on an A count that was sent into the record, not written down. So it goes on appeal. Guess what? Department wants to reverse that by stipulation right away to make it not a published decision. I'm in the background going, published decision, saying minors counsels do not have the authority to amend petitions and file a brand new count against parents, okay? But you have to be aware of these things, you have to make your objection, and yes, unfortunately, Jessica, the remedy is continuance. But you have to be entitled to do that to present a defense. Okay, do you want to promise nothing? Don't file notices of appeal after detention. Do not file them after jurisdiction, unless it's a 360B, and never, if the court simultaneously sets a 2-6, that is a notice of intent. And if you don't know and you have questions, talk to somebody. You can call us, I'll tell you. But please don't file it. It's becoming a big old headache. And the juvenile court has enough problems as it is in the clerk's office to have to deal with us dismissing cases. Okay, that's all. Thank you. Thank you.
Rachel.